Hola and welcome. Good evening. And I am fresh off of my remarks at the Coventry Planning Commission. It's January 28th. And let's just say that my remarks went over like a fart in church. Okay, people weren't happy. And if you want to watch it, I'm sure it's posted on their YouTube channel. But I learned that my remarks were not directed in the proper forum. So I'm making this video and I am hoping that it lands where it needs to. And that may be Rhode Island Ethics Commission. That may be the Coventry Town Council. That might be Channel 10. That might be Channel 12. I don't know. Maybe it just lands on Facebook. But I want to call attention to a person and an issue that I feel needs some light. This is feels like a very dark area that nobody has shined light into. And I want to factually and as impartially as possible convey to you what I've learned and what I believe it represents and what type of confidence is lost and trust is diminished as it pertains to public confidence and the public governance system that we have. So I have some remarks and I have some information that I'm going to share with you. But first, I want to give you my thesis statement and then get into specifics from there. I am submitting this statement to formally raise an ethics concern regarding the dual professional roles held by Coventry's Director of Planning and Development, Mr. Doug McLean, and the implications those roles have for neutrality, public confidence, and institutional integrity in municipal planning here in Rhode Island. This statement does not allege corruption, illegality, or a violation of any specific ethics statute. Rather, it raises concerns grounded in divided loyalty, appearance of impropriety, and structural incentive bias, all of which are recognized concepts in ethics governance and public administration. As Director of Planning and Development, Mr. Doug McLean occupies a position of significant influence over land use policy, staff analysis, procedural framing, and the moderation of Planning Commission proceedings in Coventry. And I just saw it tonight. Doug does a fantastic job. He's very, very smart and he's very good at what he does. Simultaneously, Mr. McLean has served as a paid land use consultant for private development projects in other Rhode Island municipalities, which I will get into, where his professional role is to advocate for approvals, density, zoning relief, and favorable interpretations of land use regulations. This dual role, public and private, creates a reasonable appearance of divided loyalty. Municipal planning decisions do not occur in a vacuum, especially here in Little Rhode Island. They are shaped by professional experience, precedent, and an individual's repeated exposure to a particular set of outcomes. When a planning director regularly operates as a private consultant, advancing development interests elsewhere, it is reasonable for the public to question whether the professional framework carries over, consciously or subconsciously, into their public roles and duties. This concern is not personal, which members of the commission stated very knee-jerkedly that this was a personal attack.
Okay.
This is a personal attack. This has nothing
It's
to
not
do
personal.
with
I
the
don't know Doug.
project.
I
I'm
have
sorry?
no idea. I have no idea who Doug is.
This is not personal. This is facts.
It is. To us, it is. I'm just going to stop it right there.
I don't know Doug. I've never met Doug. This concern is not personal. It is structural and cognitive. I'm a thinker. I am an analytical person by nature. Hence the pile of paper at midnight. Land use professionals develop ideological and foundational continuity through repeated practice. And Doug has been doing this for years. The senior planner at South Kingstown, the principal planner in North Kingstown, an environmental planner for the Horsley Witten Group. This is going back to 2007, so for the better part of 2 decades. Project planner at Canopy Development. Also, I believe most recently before Coventry, he was the planner in Cranston. So, that's 4 municipalities out of 39. That's 11%. 10%. He's worked at 10% of municipalities. That's big. Over time, professional norms, assumptions, and default interpretations are reinforced, especially over 2 decades. In this context, the concern is that not rules being broken, but that a planning director who routinely works on behalf of developers concurrently and simultaneously to his role here in Coventry, that person may naturally approach municipal review from a development accommodative lens, making true neutrality very difficult, particularly when acting as a moderator like he was tonight, a gatekeeper like he was tonight, or as a guide to a local planning commission like he was tonight. The concern is heightened by documented private consulting work, such as Mr. McLean's role as a land use consultant on the lofts at the Fairgrounds project in South Kingstown. In that project's official submission materials, which are on the website, which I'm going to put up for you, Mr. McLean is listed as part of the applicant's project team in a private capacity. Okay? Notably, those materials, those official project team materials, list a Coventry municipal address and municipal phone number while using Doug's personal email address for all correspondence related to that private project in another municipality. Even if unintentional, this blending of municipal identifiers with private consulting work creates a further appearance that public position and private advocacy are not fully separated. And we'll put it up again on the screen for you. You can see clearly we have Darrow Everett, LLP, law firm, Kelly Morris Salvatore, which more on her later. We have Dupree Engineering, Diane Sewell and Associates, Newberry Design Associates, Crossman Engineering. And for the record, Dupree Engineering and Crossman Engineering have been hired by the developer for the comprehensive permit that is before Mr. McLean right now. He is working with these same companies in a private capacity. And then today, I believe Dupree came up and gave testimony about this public project that Doug, he's the town planner. So he's dealing with this company in one facet, just 10 miles down the road. And then today he's dealing with them in another capacity. My point is, how can favoritism and bias not be a thing? How can he have neutrality when playing both sides of the fence? He's the umpire and he's swinging the bat for developers to get projects over the line. And in addition, on this document, we have Joseph Lombardo, who's a fiscal consultant. We have the Community Housing Land Trust of Rhode Island, And then, oh yeah, here we have Doug McLean, AICP, which is American Institute of Certified Planners, his credential, and his role on the project is land use consultant, okay, for private hire. His role is not town planner of Coventry, land use consultant. But, and here's the kicker, he lists his contact address for official project correspondence as 1670 Flat River Road, Coventry, and put that up on the screen. What is that? That is Town Hall. And in addition, he lists his phone number to the planning department in Coventry Town Hall. Call 401-822-6246. You will not get a personal cell phone. You will get the Town of Coventry Planning Department. But what's interesting here is Doug puts his personal email address, not his Town of Coventry email address. So that shows me delineation of him saying, yeah, this is personal. You can email me at any time. But if you need to mail me something, or if you need to reach me during the day, I'll be working for the Town of Coventry. So just call my office or mail me the documents to my office because I'll be working in my office. So he's receiving financial gain and benefit in public office from private developers and shuffling those cards together. So the appearance of impropriety, this is just surface level. I can only imagine what's happening on those phone calls, what's happening in those emails. Okay? So I wanted to bring up the project team form just as an example. Okay? Now back to my remarks here. Even if unintentional, this blending of municipal identifiers with private consulting creates a further appearance that public position and private advocacy are not fully separated. Okay? And that's huge. Public opinion, public interpretation is already so fragile on these projects. Similarly, Mr. McLean has been involved as a land use professional on other active redevelopment projects within Rhode Island, including the project at 1067 Mendon Road in Woonsocket. Woonsocket, I'm very familiar. They call me the Woonsocket Rocket. I developed a church in Woonsocket. I put 32 market rate apartments. So this is definitely in my wheelhouse, and Woonsocket is very familiar to me. While this project is outside of Coventry's jurisdiction, it exists within the same small, interconnected regulatory and professional ecosystem. The repeated presence of the same planning professional advancing private development interests before multiple municipal boards reinforces the perception that a single development-oriented framework is being carried from community to community, and developers know who to call to get the job over the finish line, to get it approved. Mr. McLean has established a great reputation in the private sector. Ethics standards do not require proof of misuse of resources or improper intent to warrant review. They exist to ensure that public officials avoid circumstances where impartiality may reasonably be questioned and where public confidence in governance may be undermined. Okay? This issue is particularly acute in a state as small as Rhode Island. Like I mentioned, he's been the planner in 10% of the municipalities. Where professional circles are tight, very tight, as we just saw, Dupree and Crossman, he's working with them in South Kingstown and they're working with him in Coventry. It's a very small niche business, okay? And the gentlemen, they spoke tonight, two of them, they've been in the industry for over 30 years, longer than I've been alive. So there's only so many companies that developers can call and the wires are bound to be tangled as it is, let alone adding in this public municipal role conflict. This issue is particularly acute in a state as small as Rhode Island, where professional circles are very small and very tight, precedents travel quickly, and the same actors regularly appear before multiple boards. In such an environment, the simultaneous practice of municipal planning authority and private development consulting presents risks that may not exist in larger states with greater institutional separation. We don't have that in Rhode Island. We have 3 degrees of separation between any one of us, period. What may be acceptable elsewhere, like in a Florida, a Texas, a New York, may not be appropriate here. It is not appropriate. It's not, in my opinion. For these reasons, I respectfully submit that municipal planners, particularly those who staff, guide, and moderate planning commissions, should not simultaneously serve as private land use consultants within the same state regulatory ecosystem. If you want to do it in Mass, if you want to do it in Connecticut, we share a maritime border with New York, you want to go there, no problem. That state boundary is good. It's a whole nother ecosystem, whole nother environment, whole nother set of laws. That's fine. But being able to do both in such a small state should not be allowed. At minimum, this issue warrants a formal ethics review to determine whether additional safeguards, prohibitions, or disclosure requirements are necessary to protect the integrity, the already fragile integrity, of municipal planning and maintain public trust. This request is made in good faith for the purpose of transparency and accountability, and in recognition of the importance of clear separation between public authority and private advocacy in land use governance. So I had emailed Doug my opposition remarks, my remarks pertaining to the village at Tyoke. As instructed, the public was instructed to email those to his address. And I assumed that he would briefly view them, print them out, and include them in the docket for the Planning Commission members. Because mine was very lengthy, I said, there's no way, this guy's very busy, that he's going to read every person's remarks. But he did, in fact, read my remarks. And he sent the following email. We'll put this up for you. This was on the 28th, 8:33 a.m. Mr. Rice, I have read and understand your comment. You are welcome to talk with me directly if you have questions about ethics involved in planning consulting work. There are required disclosures to employers and rules that must be followed. I've never had a private client who I ever regulated in my public work, and I've never had a public applicant who was ever before or later became a private client. There is a strict code of ethics, mentions it twice, that must be followed for planning professions. Again, you are welcome to talk with me directly if you have questions, and he gave me a different number, 401-822-9184. That is different than the one on the project team form, which was 401-822-6246. That seems like a town exchange as well with the 822, but I am not sure. I have not called it. However, nothing is off limits for public comment, and you have the right to express your opinion to the Planning Commission. Apparently, I did not, because they shushed me off the stage and said, "Get out of here. We're not having it. You're all done." And we could put up some of those remarks.
Mr. McLean is listed on this project as a land use consultant.
Excuse me. We're going to stop because right now, Mr. McLean is acting, he has a a fiduciary responsibility to the town. I believe he
I
does.
understand that.
I think your comments are subjective. There's been no, it's not directly tied to this project, and I'm not going to allow it.
He lists Town Hall's address and Town Hall's phone number on the project for South Kingston. So he's using the office doubly for your role and for his private role.
Mr. Chairman,
That's my point.
What's that? I'm sorry.
now just to say.
That is a
we're off
major
topic.
conflict.
I'm sorry.
We're
So,
off.
one second.
We're off
Yeah, we're
topic.
way off topic again.
Okay.
This is a personal attack. This has nothing
It's
to
not
do
personal.
with
I
the
don't know Doug.
project.
I
I'm
have
sorry.
no idea. I have no idea who Doug is. This is not personal. This is facts.
It is. To us, it is. I'm just going to stop it right there.
No criminal
No,
activities.
sir. No, hold on. Mr. Reyes, listen, please, you're done.
Your comment will be printed and provided to the commission in advance of tonight's meeting. Thanks, Doug, unquote. And I responded with, maybe I'll take you up on your offer in the future, but I certainly will be speaking at the commission. And I spoke, and they did not want me to speak. They did not want me to speak. And I also feel, based on that email, Doug did not want me to speak. Doug wanted me to call him so he could assuage my concerns and therefore avoid having that public comment on the record. And that is now on the record, and now it has to be addressed. And now I want to mention another specific incident where alleged impropriety can be reasonably inferred. And I'm going to put up this letter. This is from Darrell Everett, June 11th, 2024, and it's addressed to Doug McLean, AICP, Director of Planning and Development, Town of Coventry, 1675 Flat River Road, Coventry. And this is a project narrative, a pre-application on behalf of Star Capital, who is developing a substantial amount of property in the center of New England, the shopping and residential center there on the Coventry and West Greenwich line. And you're probably saying, Greg, what does that matter? Fast forward back to the project team form, and we'll put these side by side. You can see that the same attorney, Kelly Morris Salvatore, ESQ of Darrell Everett, is on that project team. And Doug is also on that project team. So he's advising Kelly in his municipal capacity in regards to a very large development, arguably one of the largest in Rhode Island's history, and simultaneously working with Kelly on the lofts at Fairgrounds, which Doug is acting in his private capacity. So again, it's that blending of these private companies and his public roles, and then his alliance with those same private companies on projects that he's hired for outside of town. And these are just three examples: Darrell Everett, Dupree Engineering, and Crossman Engineering. That I see him on both sides of the fence, profiting financially on both his work publicly and his work privately. He's getting paid twice, in essence. So I wanted to bring that up. Lastly, I want to close with this. As it pertains to Rhode Island ethics, a lot of their decisions that I've seen are always based on some type of case law that they have adjudicated on in regards to how an offense or a violation is similar to something they've previously ruled on. And I've picked out a few that have similarities, but none are quite the same. The first one is Advisory Opinion 95-102. This was in regards to the Richmond town planner. And this one addressed whether a town planner can take outside employment as a planning consultant on projects outside the town, including when the developer has done business in the town. And that is similar, but a little bit different than this case. And in this instance, the Ethics Commission had to specifically evaluate whether a town planner can simultaneously serve as a planning consultant, and treated it as a legitimate ethics question that required guardrails. So they looked into that. Okay? They looked into that matter, and I believe that they should also look into this matter. Advisory Opinion 2024-31. This was pertaining to the Chief of Municipal Planning and Programming permitted to do part-time planner services for New Shoreham, subject to conditions. And in this case, the commission doesn't hand wave planning dual roles. It allows them only with specific conditions meant to protect independence and public confidence. So we're asking for some type of guardrails, some type of structure, some type of framework, because right now it's a free-for-all. The third one is Advisory Opinion 2012-32. This was the Providence Planning and Development Acting Director, allowed outside teaching job, but required recusal on matters involving the outside entity and no use of public resources or confidential info. And in this case, even where the outside work isn't development related, the commission emphasizes recusal and separation to avoid impaired judgment and appearance issues, as we have here. So that's why I felt that one was also relative. Another one is Advisory Opinion 2024-36. This lays out the recurring factors, the nexus, which is the center of things coming and going, which is also the name of the company, the nexus between public duties and outside work, doing it on your own time and no public resources, which we see from Doug's project team form. He's having things sent to town hall and called town hall. There's that blending. Not appearing before own agency, work outside jurisdiction, and no solicitation using the public role. So that gives a checklist, essentially, that supports my theory of a structural incentive bias without, I'm not alleging illegality. I'm just pointing to the gray area that exists here. And then also, you can take a look at Irons versus Rhode Island Ethics Commission. This was at Supreme Court. This discusses the ethics framework and states policy emphasis on avoiding the appearance of impropriety and protecting public trusts. And to me, it shows the courts, the Rhode Island courts, recognize the ethics system is there to protect and promote public trust and address appearance concerns, not just proven corruption. And again, I'm not saying it's pay to play. I'm saying, where is the line? There doesn't seem to be one. So in sum, Rhode Island's Ethics Commission has repeatedly treated outside employment, including planning professionals providing planning and consulting services in other municipalities, as an ethics-sensitive area requiring safeguards, because the standard is not just actual misconduct, but whether independence and public confidence may be reasonably questioned. And that's what I was attempting to achieve today, but like I said, it went over like a fart in church. And I'm sorry to ruin people's day at that hearing and potentially detract from the matter at hand, which is the village at Tioga. But ultimately, I feel that Mr. McLean cannot effectively serve as a neutral advocate between the city and the developer based on his well-documented private career as a land use consultant. And with that, I rest my case.